All right, let's take you back now to one of our top stories, and that is, of course, the application by the Speaker of Parliament, Nosiviwe Mapisa-Nqakula, who is trying to block her arrest. And, of course, there's been quite a lot that has been said in arguments in court this afternoon in a bid by her lawyers to try and stop this particular arrest, and also the state saying that it sees no reasons for this and calling for this matter to be dismissed. But someone who's been watching these developments very closely for us is Canny Maphanga, SABC News reporter. Canny, thank you so much for your time this afternoon. I mean, we start with the reasons that her lawyers believe she should not be arrested.
Well, good evening to you, Bongiwe, and to the viewers at home. Well, the Speaker is safe from an arrest for at least until next week, Tuesday rather, because judgment has been reserved in the Gauteng High Court in Pretoria in her bid to seek that interim interdict from an arrest pending this corruption probe. We know that there is papers that were filed. That was the main application that was filed to challenge this arrest and to seek full disclosure in the matter against her. We understand from the lawyers and their arguments that they've made is that the only reason why they're seeking this interim interdict is because her attorney of choice, the right to choose an attorney, is being infringed on, as she says her attorney will only be available from the 3rd of April. So now with judgment being reserved, she has that protection that this imminent arrest won't happen until then. We've heard arguments from both the applicant as well as the NPA. The NPA was arguing that they had opposed that application, stating that there was no real grounds that were raised to challenge an imminent arrest. And they were raising this concern, Bongiwe, about what does the legal precedent set if the court grants this interim interdict and says that the NPA or the criminal justice system and all its public functions cannot affect an arrest if someone has brought an interdict, that they must give their full dockets and full disclosure before they can be subjected to a criminal process. Then you'll have many people running through the criminal justice system asking for that interim time to get their dockets, to get information before a criminal matter can proceed. Now, you know, in the criminal justice system, you'll appear in the lower court, you'll be charged, they'll list the charges, and in that time, what we've seen in the lower courts, Bongiwe, is that while the matter has been enrolled, you've seen a couple of postponements to deal with various different issues, including pending investigations. And then when the docket is closed and the matter is ready for trial, that is when what the Speaker is seeking actually happens, because it's given to you to prepare yourself in your defense at the criminal trial proceedings.
And Kenny, of course, the issue of the attorney, the NPA even saying that for them, they don't understand the fact that they now have to work around the convenience. And I'm borrowing from what they're saying, that they've never, it's unheard of to have to now work around the convenience of the attorney, and saying that this is not, in fact, a trial, and they do not understand why they have to work around this issue.
Well, it really is unprecedented, Bongiwe, to see the NPA negotiating with an individual as to when they'll be handing themselves over, when they'll be available to go to court. I mean, you just don't see that happening in the criminal justice system. People are arrested. When they get a date to appear before the courts, they go and they appear. They're given the opportunity to apply for bail. If it's denied, they go back into custody and they defend their case to the very end. So it's quite interesting for her lawyers to be arguing that, of course, they're not saying she is above the law, but they're recognizing that she is an individual, an influential individual, one who enjoys those rights to not have her dignity infringed on through an arrest. And they further arguing that what they seek to do does not require an arrest to take place. They could have processed her and taken her to the court. So it appears that the biggest issue for the Speaker here is being put behind bars or behind a cell or behind a jail, arguing that she would suffer irreparable harm and that dignity would be impaired. But the NPA is arguing that many South Africans go through this very criminal justice system, and even what she's arguing about her dignity being impaired, a lot of this case is being reported on by the media. It is already out there that there is this corruption probe that she will have to answer to. So no dignity has been impaired, and she cannot claim that ground in order to evade arrest.